Any adjournment request? Delete this for orders. Number one. Lordship, in respect of respondent number 7 and 8, we had filed the dusty service affidavit on 9th of June, my lord. The respondent 7 has entered appearance and respondent 8 has not. 9th of June,
9th of June.
my lord.
Dusty.
My lord, 2nd of June, sorry. 2nd.
6. Eight. Regarding 7 and 8.
7 and 8, my lord, page 101.
7 file Lukas Nama.
Yes, 7 file. 8 is not interested, it appears, my lord, because we get 7 has already been given the work order.
With 8.
8, another tender, which rate is higher than that's number 7.
Okay.
So work order has been issued in favor of that's number 7. And that work order was subject to my lord.
Dusty affidavit. Dusty affidavit.
The Federal Services that
18.6. Separate file. Separate change. File on 9.6.
page 98. my lord, that
Of Francis. Yes.
my lord. So they are sad now.
Membership, since the petition was disposed of at the motion stage itself. They have also filed an additional affidavit, which I call it still a motions.
Well, it may come up for revision, my lord, on Tuesday. With tender matter, my lord, it can be. Okay, we shall supply today itself.
Heard Mr. Z.N. Sahiwal and Senior Counsel listed by Mr. M. Sahiwal and Counsel for the petition appellant. Read appellant, Mr. R.K. Deputy Solicitor General of India. For the respondent number 1 to 6. And Mr. R.K. Bora, Granite. Counsel who has entered appearance for the respondent number 7. Post of para. By order dated 21/5/2025, the petition, writ appellant was allowed to serve notices upon the respondent number 7 and 8 by registered post with AD as well as by dusty post of and additional
Attribute of service.
a compliance affidavit to that effect has been filed by the appellant, writ appellant on 2/6/2025, stating that notices were served about the respondent number 7 and 8 by way of the state, annexing therewith receipt of acknowledgement of the notice by the state to respondents. Postal. The in view of the statements made in the state compliance affidavit as well as and on perusal of the perusal of annexus C to the state affidavit, the service of notice upon the respondent number 7 and 8 is treated to be complete. Postal. Respondent number 7, the respondent number 7 has already entered appearance. However, none has appeared for the respondent number 8. Till it postal. Para. What pleadings have been filed by the appellant? Any more?
One additional affidavit, my lord, because.
That is on record.
Yes.
Okay. Mr. Dev Choudhury, learned DYSUI, has submitted that the writ petition was disposed of at a motion stage without having any occasion for the respondent 1 to 6 to file its counter affidavit. Also, in this writ appeal, and a counter affidavit on behalf of the respondent number 1 to 6, 2 to 6 has already been filed on.
Yes, sir.
Okay, that to review. And the said counter affidavit is not on record. So he has sought. Okay. Moreover, an additional affidavit.
Definitely reply to the action.
Okay. An affidavit in reply to the additional affidavit. Moreover, to the additional affidavit filed by the writ appellant, an affidavit in reply has also been filed. Okay, yesterday, huh? Full stop. The said pleadings are not on record as on date. Yes, has sought. Mr. Choudhury has requested to bring the said pleadings on record. So, the learned counsel for the appellant shall furnish copies of the pleadings to Mr. Bora during the course of the day.
Yes, my lord, only additional
Okay.
affidavit, my lord.
During the course of the day. Post of. Okay, and Mr. And counsel for the. Okay, writ appellant and the respondent number 2 to 6. Shall serve the copies of the pleadings filed on their behalf to Mr. Bora. And let counsel for the respondent number 7 during the course of the day. Post of. The respondent number 7 may file its response on or before the next date of listing as sought for by the learned counsel for the parties. Please the case. Fine. That is also a reasonable prayer.
Let it be on 26th, my lord.
26. We don't know. Before vacation, okay. 26.
For admission, my lord.
In the admission.
For motion, item number 2. It will be taken after some time. List. Item number 21.
May I please, the lords? Lord, the matter relates to Milord and the nature of an habeas corpus, Milord. Milord, the sister of the petitioner, Milord, had been declared to be an
Who is the state council?
Mal. Wait, wait.
Mr. Deputy. Habeas corpus.
Foreigner, here, take the post back.
And state council. Initially, we can ask for about whereabouts,
Mal, that's enough, Milord.
about the, we can ask them to obtain instructions where the
Presently detainee is Milord.
person is, who is Mr. A.R. Bhuiyan. Where is Mr. Nath?
He is on back house.
You can represent him. Or Mr. Pine. What a party. Oh, only name is shown D as
Mal.
ZI. Without the copy
FT Milord.
not reflected, either Mr. Pine or Mr. D. Nath.
Milord,
No name is showing.
correct, Milord. Let's check the post list also.
Hmm.
But I will, if my lord allows me, Milord, I will inform my learned friends, me.
Yes, Mr. What do you suggest? Deputy?
Since Habeas corpus, should we get informed?
Okay.
I think that would be sufficient.
DY, Mr. Deputy and Deputy Solicitor General for the response number 1. First of the extended petition under Article 226 of the Constitution is preferred seeking a writ in the nature of habeas corpus or any other writ, order or direction. Post of para. The case projected on behalf of the petitioner is that in brief is that who is the person, how you are related,
Mariam Begum is this,
how you are related,
I am his, Milord, elder brother.
the sister of the petitioner,
Mal.
comma, Morium.
Begum.
Where is the name?
Lord, is that, prayer part at page 15.
Huh?
Page 15 prayer part.
Not in the pleading. Page 2. No, Bitorot, paragraph. Bitorot, nahi. Comma, Morium, prayer person sabo. Begum. Has been picked up from her home at
Lord, at Chirang, what the detail is given, Milord. Village, Shashipur under.
where it is written for me and
Mal.
him to dictate correctly, type correctly.
Yes, Milord. Milord, then page 11.
Is 11.
Milord, I'm sorry, Milord, page 9, paragraph 8, Milord.
I know that is Tamulpur bliss,
Mal.
but very
Paragraph 8 and
no,
9, Milord.
any village, anything.
Yes, Milord, the village. Milord.
You have right all this. Article 21,
Yes, yes, my lord.
but basic minimum details are not there. It looks like.
Village Sasipur, my lord.
Where
village
is
Tamil.
that?
Lord, I have annexed
In the
the
entire pleading?
voter I card at page 26. and
Oh, you have to go for voter I card.
I'm sorry, my lord, it should be there, my lord. Mistake on the part.
Or in your FT order?
My lord, FT order I have annexed, my lord.
But is it mentioned there?
My lord, thereafter, in the Mariam Begum was illegally.
NK Doronga village. Which one is your village?
My lord, presently I am at Tamulpur, under Tamulpur police station, my lord.
That I know.
My lord. And the,
But if we don't know the village also,
my lord.
petitioner is at Sasipur,
Correct, my lord.
but the LS detainee by the police personnel from Tamulpur police station in the night of 2000, in the night of 25/5/2025. And since then, Commander whereabouts of Moriam Begum is not known to the petitioner. Full stop. It is stated that a proceedings was initiated before the Foreigners Tribunal, Nalbari, by FT case number, FT Nol B, so and so, so and so. For determination of citizenship status of Moriam Begum. Postal. Paragraph 8.
In between,
I have,
he said that push back. She has been pushed back.
My lord, we have been informed by the police, but whether thereafter, my lord, there is no whereabout, my lord, whether pushback or not. Difficult.
pushback, then no, let us find. Okay, we'll record that you have pointed out.
My
By an order stroke opinion dated 19/3/2012, comma, the Foreigners Tribunal, Nalbari, I declared Moriam Begum as an illegal migrant stroke foreigner. Postal. Thereafter, comma, Moriam Begum was detained at detention center on and from 5/8/2015. Post after a period of 4 years and 2 months. Comma, Moriam Begum was released on conditional bail in terms of an order dated 13/4/2020, passed by the Honorable Supreme Court in suo motu WPC number 1/2020. Post op. It is stated that since then, comma, Moriam Begum has been complying with the conditions of bail. Post op. Para. Mr. Devchuri and DYSDY has submitted that in paragraph 8 of the writ petition, the petitioner has averred that Moriam Begum has already allegedly pushed back forcefully across the international border without any order or declaration from the Foreigners Tribunal as mandated under the Foreigners Act 1946 and the Foreigners Within Bracket Tribunals Order 1964. Para. Be that as it may, since the petitioner has projected that since 25/5/2025, the whereabouts of Moriam Begum is not known, the state respondents shall obtain instructions as regards to whereabouts of Moriam Begum and place such instruction before this court on the next date of listing. For the purpose of obtaining such instruction from a learned counsel for the petitioner, serve an extra copy of the writ petition along with annexer to Mr. Devchuri, and so for the respondent for service of notice of the respondent number 1 and Mr. Z. Sharma. Okay, Z. Sharma, standing counsel, home and FT matters. So the respondent number 22.
P. 2, 5, 6, 7.
And whose name should be recorded? Respondent number 4.
Yeah.
Mr. and for it, state counsel for the respondent number 4. 2 copies to Z. Sharma, 2 copies will connect, sir, and 1 copy to Mr. Polita during the course of the day.
Yes, sir.
Please the case on Wednesday. Wednesday.
Obliged, deeply obliged.
I got about 3 for a piece of.
Visual also.
Hmm.
My lord, this is an appeal, my lord, under section 19(1) of the family code, my lord, against the order, my lord.
Item 6.
Admit. The learned legal counsel. I need to. Yeah, I took my money. My legal counsel for the appellant is found absent today on call. Also, however, Ms. Message Bora, learned traditional public prosecutor for the respondent of Kama State of Assam is in attendance post of the instant appeal under section 4152 Nagoric so and so is directed. Yeah, it was a we have gone through the so and so. The criminal appeal is admitted for hearing. The case records of so and so. We call for issue notice returnable in 4 weeks as Ms. Bora has appeared for respondent number 1. Extra copy of the memo of appeal within 3 working days. Steps varied. Upon the respondent number 2 informant as per the practice direction. the addition public prosecutor is to obtain service report as regards to answer from the officer in charge to your police station or not before the next day, by the next day of this.
Item 7.
My lord, matter on the agent for the day, my lord, I have already informed the other side, my lord. Due to some personal inconvenience.
Okay. Mr. P.J. Fukan, learned counsel for the appellants, and Mr. M.M. Kaishap, learned counsel for the private respondent, my president. Mr. Fukan has sought an adjournment of the case. And Mr. Kaishap has submitted that he has no objection to a said trial. Also, in view of that, in view of the above submission made by the learning counsel for the parties, the matter stands adjourned for the day.
My lord, can it be taken up immediately after the case, my lord?
Okay. Okay. Stands adjourned as sought for and agreed to by the learning counsel for the parties, list the appeal.
Appeal.
Okay. On a date immediately after answering summer vacation.
Most of.
Made vigilance. But in this appeal, the appellant has put under challenge a part of the judgment to the learned civil judgment. What happened in this case, my lord, appellant here is the senior most professor in a homeopathic college.
Huh?
In the homeopathic medical college, he is the senior most professor.
More. Yes.
And the government, my lord, by impugn notification dated
What is the judgment?
judgment, lordship will get it at page 107, my lord. No, page 100, my lord. It starts from page 100, the operative portion.
You are the petitioner.
There
petitioner.
was the petition, my lord. By impugn notification, my lord, respondent number 4,
What was the result in the?
result is that, my lord, that notification has been set aside. Notification is set aside and quashed, but, my lord, by the strength of which
Respondent shall fill up the post of vice principal.
paragraph 22 and 23, my lord, page starts from page 110. Paragraph 22.
20.
22, my lord. Having considered that the respondent number 4 is not eligible to be promoted to the post of vice principal in the homeopathic medical college, and considering that there is a draft rule, that is Assam Homeopathic Education Service Rule 2023, and the respondent number 4 is currently serving as a reader, I am of the considered view that the appointment of the respondent number 4 as vice principal, even though as an in charge for a temporary period, would not be sustainable. As even for temporary appointment, one must be eligible, and the petitioner by now has become eligible for the post. Thus, the appointment of the respondent number 4 to the post of in charge vice principal is not sustainable, and accordingly, the impugn notification dated 11/11/2024 issued by the Commissioner and Secretary to the Government of Assam Medical Education and Research Department is hereby set aside and quashed. Consequently, it is directed that the respondent authorities shall fill up the post of vice principal of SGN Homeopathic Medical College and Hospital, Guwahati, on regular basis by following the rules, that is either the draft rule 2023 or the aforementioned regulation 2024, whichever is applicable, within a period of 4 months from today. However, it is provided that the respondent number 4 shall be allowed to continue to hold the post of in charge vice principal of SGN Homeopathic Medical College till the post is filled up on regular. I am against this part. The notification by which respondent number 4 was posted as in charge vice principal, that has been set aside, and on the strength of which has gone, again he is allowed to continue till regular promotion. I'm against that. And I am the senior most professor and learned Honorable Single Judge.
What is this regulation 2024?
2024 regulation, my lord.
What is?
It says that for the
What
post
is
of-
this regulation? It says IPAP.
My
Let
lord,
us see the name first.
it is the supplied a copy.
It is part of the record.
No, my lord.
Part of the record. What is the name? Name of the regulation.
Name is, my lord, Homeopathy Central Council minimum standards requirement and homeopathy college regulation. Right?
Central regulation.
Central regulation, National Commission for Homeopathy Regulation.
Where is the impugn order
It is below.
in the writ petition? What was impugned in the writ petition?
It is at page 64 of the appeal. Right? Page 64.
Hmm. So he is reader and HOD.
He is reader
Huh.
and I am the professor. And as per gradation list, my lord, I am
Professor.
professor. I am
Hmm.
professor. And as per gradation list,
Huh.
I am the senior most. He is at serial number 26. I am at 11, but 1 to 7 has already retired. 8 was holding the post of principal. 9 and 10 expired. So now I am the
Where is the
senior.
graduation list?
Gradation list. It is at page 48, my lord. It starts from page
Graduation list.
48. There is the notification, 29th of August 2019. And then page 50, Lordship will get at serial number 11, name of the appellant. Page 50.
Who is the principal?
Principal was at serial number 8, my lord.
8.
8.
Deep Kumar Medhi.
Deep Kumar Mehdi.
Okay.
He was the principal. He was holding the post of
And
principal.
you are Vaikuntha.
Yes.
And who is the
Respondent
respondent?
Lordship will get at page 51, serial
Manoj-
number 26.
Manoj Kumar Dekha.
Serial number 26, page
Hmm.
51.
So, after, when you moved the reappeal, what is the order? You are agreed by that
I am agreed by that.
Manoj
part.
Dekha's continuity?
Yes, my lord. I am agreed by that. And
Hmm.
my lord, in fact, learned ordinate bench, my lord, so number 2,
Huh.
passed the stay order on the first occasion, but on the prayer of subsequently, prayer was.
Stay order?
That is not here, my lord, that was modified on the same day, as because learned additional advocate general was
No,
supposed
there
to.
is no reflection.
No, it is not reflected. It is
Then
not reflected. Learned additional is.
what is not there in the
No, my lord, it is
record?
subsequent to that, my lord, he made the submission that he will take instruction accordingly. It was made. It was posted. In last occasion also.
Take instruction whether any other eligible professor is available for holding the post of vice principal in the concerned college.
Another professor was there, my lord, serial number 12, as per my instruction.
Homeopathic medical college colleges. This gradation is for homeopathic medical colleges.
Colleges.
How many?
Earlier there were 3 colleges, now all are amalgamated into one.
Only one.
Earlier 3.
In Assam, only one. Okay, so this is this is meant for all purpose. Okay.
But today we are facing a difficult, just around 5, just 3 days prior, the order was passed. The judgment was passed. The principal mallet was suspended.
Huh?
Based on that mallet, after interference of the binding on the court of the insert principal simple respond of 5. Then there will no mallet principal as well as not.
But
That
appellate
does
is the
mean
senior.
8-5. 8-5.
Yeah.
Then what?
The principal was suspended.
Principal, he is full-time principal,
No,
or
in
in charge
charge.
principal. All in charge.
Now, when the person to the order is about the court, we have already initiated drive. Shortly, the advertisement will be issued. So, when we pray that this honorable court is allow whether the respondent of court to continue for the 4 months. 1 month has already left. For next 3 months, in between that period, we'll complete the process.
But not when order notification which is gone on the strength of which is there.
Document check para,
So, my lord,
23, page paperwork.
Just to bring mobile. Five. And why he is not given the appellant is not given the in charge? Huh?
There is no, I am,
That legal matter was not placed, but matter, they, the situation is this. Otherwise, matter, they will suffer. Some bureaucrat will have to sit there.
Hmm?
Some bureaucrat will have to sit there.
Hmm.
so I am the senior most from the, I am entitled to that. But instead of
Is
that,
there anything that why vice principal has been given to the private respondent?
There is- in the,
Over and above the petitioner or
in the
appellant?
affidavit, my lord,
Is there any reason?
Matter,
in the affidavit, their stand is that,
Apparently,
page 106, matter, para 30.
apparently he does not have the qualification.
That matter, the PS.
And that is also appears to be for in charge also, that is the correct position. Para
13, page 106.
10.
Six. Internal page 7 of the.
13, para 13.
Para 30.
You say that you follow the norms for principal
Well,
as per the Central Council of Homeopathy
Yes.
regulation.
but according to that,
Uh-huh.
he is not eligible.
Now, court has held that he is not qualified.
PS matter as professor.
Uh-huh.
Degree college. That is the criteria. Or
He is
associate
in
professor with 7 years of experience.
But he is reader and
But what about, you said so in paragraph 13 that private respondent was allowed to hold
Yes.
the charge of vice principal on that basis. Ultimately, determination is made that he is not qualified. So, if he is not qualified, he is not qualified.
Then make the arrangement.
So what arrangement? Why the appellant is not made in charge? Huh? Is it not the writ petition case?
petition.
Huh?
My case is.
What
I
is the
was-
prayer in a writ petition? Because everything has been done, but the last part is that he should be allowed. Till the post is filled up on regular basis.
Yes,
It is already held that he is not.
paragraph in the petition. is
He
39.
already said one must be eligible.
Yes,
My lordship is the prayer made in the writ.
Huh?
That was before.
Then
the
that is why I am asking.
Page 40.
Page
40.
40.
Yes, for this.
I was praying
Ah.
for from
My lord, that my lord impugn.
Shall not be set aside notification issued by the commission.
He played for his promotion,
Hmm.
not for his conduct in church.
Hmm.
Wanted that discipline my lord set aside and regular selection should be done. And we are working on it.
my prayer is for setting aside that impugn notification.
All right. Right.
But
11.
if that goes, I am the senior.
Whereby respondent number 4 was,
Allowed to work as in suspension, as principal.
that was
Set aside.
set aside.
That
Then
was
what
my
is your
prayer.
next prayer?
My next prayer was that, Lord, I am promoted. Till promotion, I am the senior most.
Promoted? No, here is a case of promoter.
My lord,
Promotion.
promotion.
Regular.
Because in the that order
May you
also,
please to direct the respondent to promote the query. That exercise has been directed,
that
is it
actually-
not?
Yes, my lord.
Is
But
it not?
he cannot as that notification goes, my lord, on the basis of which he was there.
And the same judgment, it is observed, Mr. Gogoi, that even for temporary appointment, one must be eligible.
Yes, man, I am held as eligible, my lord.
No, it is a different thing. No, you are on in-charge now,
My lord,
but there is no prayer for in-charge.
that is, I was praying for promotion. That I agree.
Don't extend the contours of your writ petition.
And but the subject to lordship
No,
permission, there
no,
was
no.
any other-
You have to be very
any other
specific.
order.
No, any other order will not do. There is no prayer that leave him, make me in charge.
Because, my lord, in the impugn notification, there was no mention that he is allowed to work as in charge. He is allowed to work as vice principal. That was the wordings. That's why, my lord. So,
Gogoi, this part shall not remain then. In this part, last part. This cannot, if it is held to be illegal, it is held to be illegal.
Yes. Lordship is absolutely right when Lordship has said that part is illegal, no we can be legal. But certain situations sometimes comes, my lord, Lordship accordingly passes the order. I've got one order about this court division with my lord, I'll just show you. Before that, I want to submit my lord. In page number 40, Lordship is seen, his first prayer is to set aside and wash. That is the allowed. His second prayer is direct the respondent to promote. My lord, always it is to consideration for promote, no direction for promote, caution for release. That also is be allowed for full-time basis. Now, against that order, my lord, case filed the writ petition. And on 22/11/024, notice was issued on this case. Also, it was directed on the subsequent day, next day, interim prayer should be considered. On next day, my lord, 13/12/24, no interim order was passed. So the matter was disposed of on 8/5/24. So from the date of first issuance of notice till the disposal, it was 6 months, 9 days.
Which one? Writ petition.
Writ petition. Thereafter, when this appeal was filed, my lord, now after disposal of the writ
No,
petition.
those things gone. Ultimately, it is set aside.
That's what I'm saying. I'm coming.
That is not material.
I'm carrying. No, my partner was saying is, there it has gone 6 months. Now today is gone 112 days. It remains only 75 days.
So
So,
the enjoyment should be continued.
so by, on the basis of pilot.
It relates back that from the very beginning, your enjoyment is illegal. Just because
my purpose of saying is, if my lord could wait for 7 months, another heavy will not fall for 75 days.
No, heaven is not going to fall for everybody.
Yes, my lord, no. There's
State
no-
can make,
There is no limit on this, if it can help my lord, be by. What's the judgment?
tell me tell me the judgment, in those judgments, before looking into it. A person is held to be illegal to hold the office even on in-charge basis. And thereafter, he was allowed. Is it the order?
My lord, division bench, my lord. What happened?
Huh.
My background, let me tell you. From the case Nagade, the person was picked up and put in the chair. The Honorable Single Judge rightly said, set it in post, and the authority shall make arrangement for regular appointment within a period of 4 months or 6 months. So job has gone. Against that irritable fine, I appeared, my lord. So I made a prayer that case is worse case than this. At least there is an interim order to continue. There are no interim order. Set it in post. So we made a prayer before the court, my lord.
Mr. Gogoi, you take your instruction who should be run the affairs of the college. As the
Just last sentence can I see once, my lord. And division bench.
No, I don't want to look into that. Once illegal, it is always illegal.
No, there also it is illegal. So no.
Illegality is not to be perpetuated.
That's true. In spite of that, my lord.
Learned senior cannot claim for negative equality if someone was.
No, I'm just saying the judicial principle for nothing else, my lord.
Doctrine of necessity, they will make
Yes.
arrangement. They will make arrangement.
That's what. That's
You are-
arrangement. No issue. my
Ah,
lord.
That-
No
yes,
issue.
because he has not made the prayer. To make him
That
in
is
charge.
what I want to make submissions.
Ah.
If they are allowed only.
Huh.
All is there allowed.
Right.
Take steps for that.
But once illegal, that illegality cannot be perpetuated.
But my lord, what we do?
They-
What falls from this side, we follow. This is what fallen from that time, mercy and the sympathy, nothing else. My lord. At this stage, the learned counsel for the my lord. Till the process of selection advertisement is made, applicant be permitted to discharge his duties since he has been appointed as Habeas successor. Cannot discharging his duties till the order of running single judge set aside. In that view, a matter of present nature, since in even the order of learned single judge will have to be implemented, and the process of selection is to be made by issuing fresh advertisement. Till such time, in the event, the official respondents may also require to extract the work only in order to balance the equity. We find it appropriate to allow the applicant to continue with the post subject to further clarification that process of selection after issue of advertisement be completed in time frame. In view that we direct official respondents will comply with the direction issued by the learned single judge, and in any eventuality issue such advertisement within 1 month from the date of this order. The process of selection shall be completed within a period of 3 months thereafter. In other words, the entire process of selection pursuant to the order passed by the learned single judge shall be completed within a period of 4 months from the date of order. Until such time, applicant shall be permitted to discharge his duties. It is clarified that if the process of selection is not completed, in the said process, if the applicant does not succeed, official respondent shall in that event relieve the applicant at the end of 4 months from the date of this order. Here, totally illegally was appointed, my lord. Single judge is found, my lord. That's why I said, my lord, how many days? There are 75 days left, my lord. And if they cannot complete, my lord, lordship may direct, my lord, I will be out after 75 days.
No, this kind of, if order is passed, then everything.
Principal
Not
also,
also,
but I am not
but
even charged.
Judicial Committee will
Since 5/5, principal has been suspended. Nobody is given charge.
Mr. Mehdi, you are found to be not fit for them to hold the charge of vice principal. How can you expect that you'll be found fit for holding the charge of principal?
No, Honorable Single Judge has held that I am eligible for that.
Eligible.
And I am the senior most, my lord. That is the procedure. I am the senior most. I was, after at least suspension of principal, I was supposed to be handed over as such. But till that, government is doing nothing, and respondent number 4, after this order also, my lord, respondent number 4 has been allowed to work as DDO. 19/5. Who is not eligible as held by the Honorable Single Judge.
What is the order there in your this judgment? Single judge order?
No, it starts from page
No, no,
100
Mr. Nath.
regarding my eligibility.
That was set aside in first.
Page 100 and
No. That is number. My lord, in page number 2, in the middle, just middle below, in that view, learned single judge being of the opinion that in a matter of public employment, such procedure not being followed would not be sustainable. Accordingly, appointment of respondent 4 was.
Oh, that great for landowner, Nagaland,
Yes, that's why I said.
landowner.
Landowner, there's a promise made by the government to the landowner. That was, he made it, I filed a case against that particular respondent 4.
Policy.
But that is gone. That has
No.
nothing to do.
No, this case is regarding landowner's appointment.
No. Landowner.
Your case.
Promise was made. That land is given by his father. So in the family.
Mr. Nath, I have dealt with
Yes.
already
That-
at least 50 cases of this kind.
Yes.
Right? Landowner case in Nagaland.
No, but the
Is it
appointment-
not?
Yes. No,
Yes,
But the appointment was made to somebody else. That was.
yes, that is the issue.
Yes.
It is a policy. It is a policy. No set of rules. No set of rules.
Yes,
It is only Article 14 and 16 in Nagaland,
yes, my lord.
grade 4, grade 4 post, peon, not above it. This order, this judgment is landowners on the basis of the claim that his father, grandfather donated land for establishment of school or
Some of
office
the-
because land in Nagaland belongs to the people, not to the state. They donate, and there is an agreement normally that after establishment, one of your family members will be given appointment.
Yes,
It is a basis of agreement. Right?
Yes.
This person might have gone to the High Court claiming that my family has been deprived from getting the appointment and Article 14 has been violated. Is it not?
no, not only this, one more extra. Oh, Respar 4 has been appointed.
Right.
Yes, that was satisfied.
Yes. In Kohima bench,
Suima bench, yes.
you will find at least
No, number of
3,000.
cases like.
Same case. All without appointment, selection process, right? Yes, Mr. Gogoi. We are of the view that judgment of the Korean bench is not similar. That is lowest rung in the institution where he was not running the affairs. Here it is a case. He will be running the affairs of the college. Vice principal, he is not eligible. Meaning thereby principal, he is not eligible.
Lordship will leave it to the government.
And if it is eligible person is there, you make arrangements. Since he has not paid for that, we will not say so.
In
That
appeal,
petitioner, but whoever is eligible to
whoever is
hold,
eligible- Whoever is eligible.
The government take a call.
government will take a call, but whoever is eligible.
One.
Eligible person is not to be allowed.
Yeah.
And there is a difference. That is a peon, here is a head of the institution. And
But when a lawsuit is, there is criteria prescribed for the post of vice principal. That I must clarify. Only for the principal, there is a qualification prescribed. In fact, there is the post for vice principal. Regulation.
In
now
other
you are
cases,
following same.
That is their stand.
That is your stand now.
In the affidavit, that is their
Same
stand.
qualification.
Yes. You have to follow some.
You have to follow. That is your stand.
That is their
Is it
stand in the
not?
affidavit. Yes.
Okay. Mr. Nath, anything to say?
And in appeal, I have an interim period, I may be allowed to hold that.
No. That observation.
Lordship, I leave it to.
But
Ali.
the government is taking a call that they will compress some officers to be there for the time. That my submission will be recorded.
No, if in the gradation list, somebody is eligible, then
Eligible, not in terms of that, criteria of 7 years or 2 years. There will be some other-
eligible to hold the post of principal, it is up to you.
Yes, roughly do it. Only thing, ineligible person will not be. eligible.
Yes, no eligible. Heard Mr. K.M. Haloi, learned counsel for the appellant. Mr. B. Gogoi, learned additional advocate general. For the respondent number 1, 2. Nobody is principal.
1, 2, and 3. Or now it
Now,
nobody is.
so
Nobody is principal.
Now nobody is.
That is a unique situation, I think,
otherwise, the college is there. So,
for 3 and 3. And Mr. M. Nath, learned senior counsel, listed by Mr. A. Bhattacharya, learned counsel for the respondent number 4. Full stop. This intra-court appeal is preferred against a judgment dated 8/5/2025, passed by the language single judge. In a writ petition WPC number 6110/2024 postal. Para. In the writ petition WPC number 6110/2024, the appellant herein as the petition had a seal What is the notification? 11/11
Page 64.
had a sale, a notification dated 11/11/2024, passed, issued by the Commissioner and Secretary to the Government of Assam, Medical Education and Research Department, whereby the respondent number 4, a faculty in the rank of reader, had been allowed to work as vice principal of SJN Homeopathic Medical College and Hospital, Guwahati, in addition to works already assigned to him. First of the writ appellant this petition had also sought for a direction to the respondent authorities to promote him as vice principal Sohit Jadhav Nath, I go to SJN, within bracket, the homeopathy college for short, to promote him as the vice principal of the homeopathic college after setting aside of the notification dated 11/11/2024. Post of para. The writ petition or the main ground of challenge in the writ petition was that the respondent number 4 did not have the eligibility. It is a promotional post.
Promotion, yes.
Did not have the eligibility to be promoted to the post of vice principal of the homeopathic college, and as such, he was not eligible to hold the post of vice principal even on in-charge basis. Full stop. Para. While adjudicating the writ petition, the learned single judge, after considering the draft Assam Homeopathy Education Service Rules, 2023, and the Central Council of Homeopathy CCH regulations, came to a finding that the appointment of the respondent number 4 as vice principal, comma, even as an
Point, but this regulation, something is wrong.
Hmm.
Taking some time to do 2 minutes time. Otherwise, if you very many duties, then I think. About eligibility criteria, social criteria. I'm sorry, I'm just.
you should have priced this code
Yes,
and the
yes, yes,
earlier when I started dictating it was very
Yes,
disturbing.
stop it, yes. Just we look at it.
Line to 6 corridor.
Page number 1
Even on inches basis for a temporary period. In view of the settled proposition that even for temporary appointment, comma, one must be eligible. Full stop. The learned single judge has held that the appointment of the respondent of 4 to the post of in charge principal is not sustainable and has set aside the impugned notification dated 11/11/2024. Yes.
This regulation 2024. The one record by the Honorable Single Judge. Page number 113. This big one, this one. Page 113.
113. 113.
Got it, madam?
Hmm.
And is the left side, my lord, schedule, third schedule. Qualification for teaching, non-teaching and hospital staff, medical institution and attached hospital. General, principal, medical superintendent, professor. This is the qualification. See the seal number 6. Promotion or transfer of existing teacher from one institution to another. Now, if we stop here, comma, it's not there. Shall be as per regulation effective at the time of his appointment. Promotion. Question is got it, final. Now, right side kindly see. B, next page. Qualification for teaching staff of homeopathic medical institution, principal or director. I think, my lord, this particular college this comes under A. This one. Because hospital attached to this. So if it comes under A general, their promotion or transfer of substances shall be as per regulation effective at the time of appointment. So this regulation came in 2024. Before that, the other one I have given the copy. Other copy, my lord, kindly just read it once. I may be wrong, but just I feel little loss of notice. Regulation 83. Next page, kindly, sir, my lord. Qualification. Qualification, principal, essential qualification. Post-religious qualification in homeopathy, holding a post of professor stroke reader degree level. That's what is making me little.
But you have not challenged this judgment.
I have not challenged, and on the point of law, I'm just trying to disclose nothing else.
Regarding that,
I don't want that.
Regarding that, that was dealt by the learned single judge. It was pointed out, that was dealt by, and learned single judge's observation is that, my lord, that subsequent regulations, 2013 and 2024, these are in supersession to earlier. That has been held by the learned single judge. And apart from it, my lord, even if we assume that he was appointed in the year 2002, while that was holding the field, but the feeder cadre, even if we assume that reader is eligible, respondent number 4 has become reader in the year 2023. At that time, 2013 regulation was holding the field. then also 13 will come. In 13 regulation, it is provided that only professor, not reader at all. Reader, associate professor, nothing. That has been dealt with by the learned civil. This was
No,
pointed out.
why this, Mr. Gogoi, this CC,
It is
They
NCH
can
regulation.
clarify about this point, which one is applicable.
no. National Commission of Homeopathy 2024 regulation. Why it has not, oh, so this is vice principal. Vice principal. This is principal.
All are principal.
That is
So,
yours, theirs then.
there-
2024 principal, same qualification.
Now the 2024 regulation also. And what I'm trying to say, Lordship, simple that just said about 24 regulation. But if 24 regulation, it is written, my lord, that page 113.
But subsequently,
what
specific
I'm
qualification are mentioned. Specific provision is there regarding principal or director.
That's only if they.
It is
clarify
general, the
government-
qualification, heading is the qualification, then column is general, next column is specific, the qualifications for teaching staff.
So some mic of this, no? Because simple judge also said about that following of this regulation 24. Something is somewhere missing.
Single judge has in paragraph 18. has held.
Paragraph 14 is point.
18.
18 it is
Uh,
dealt with.
hmm.
In 18 it is dealt.
Relevant provisions will be 2024 regulations.
Yes,
Yes, the 24 regulation.
It has been held, it is now.
No, yeah, that's true. 24 regulation, I mean, there are, the right side is A, left side is B. That's what, man, which one, that's what you say. It's not
There is a
24.
judicial determination now.
Yes, A, B, they both
There-
principal.
There is a judicial determination against you. So first duty for you to challenge it and to
I asked my
do the
client,
correction.
I told my client, this argument I cannot make, but since this is a law point, I'll just take picture.
No, it has been
Otherwise-
held that therefore the relevant provisions for regulating the vicarious post of faculties in so and so will be 2024 regulation.
Now,
Wherein the essential qualification for appointment of so and so principal would be the person serving as professor, holding a post of not less than teaching cadre of so and so for a period of not less than 2 years, or an associate professor 7 years.
yes.
It has been categorically held. Para 18.
I could have argued that
Correct.
better had I feel like, probably, my lord, because A and B, I could have changed that one. But since
No,
I-
it is up to you to challenge. Otherwise, this has been
I'm
held
saying-
categorically.
I'm saying-
It is he. It is
here-
he who has challenged.
Exactly. That's why I said, but the limitations on my part is this.
Oh,
Because
yeah, in an intra-court appeal, the issues
Yes.
are very limited.
Yes. Because.
কোন কিনতে আসে? কোন কিনতে আসে? In reaching the above finding, comma, the learned single judge has found that it is the provisions for the relevant provisions for regulating the various posts of faculties in the homeopathic colleges would be the National Commission for Homeopathy, within bracket, minimum essential standards for homeopathic colleges and attached hospitals, bracket close, regulations, comma 2024, within bracket the regulation 2024, wherein the essential qualification for appointment stroke promotion to different posts holding the post of principal, which would be a person serving as a professor holding a post of not less than the teaching cadre of professor in a degree level recognized homeopathic medical institution for a period of not less than 2 years, semicolon, or an associate professor with recognized postgraduate degree and teaching experience for a period of not less than 7 years in the cadre of associate professor, 109 books. The single judge has further tentatively observed that since the petitioner or appellant was promoted as professor by notification dated 25/1/2023, he would be eligible to be appointed stroke promoted to the post of vice principal as per the regulations 2024 for the post of vice principal if it is applied for filling up the post of vice principal, post of Kara. In the writ petition, comma, a stand has been taken by the state respondents that to the effect that in the 2024 in the regulations 2024, inter alia to the effect that there is no, sorry, the regulation 2024 is silent on the matter of qualification or eligibility criteria for the post of vice principal of homeopathic medical colleges. And in the absence of clear-cut guidelines for appointment to the post of vice principal of homeopathic medical colleges of Assam, comma, the basis of eligibility criteria laid down for the post of principal in the regulation should be applicable. Post of would be followed. Post of Kara. The instant intra-court appeal is preferred by the appellant petitioner. Aggrieved by the observation of a learned single judge in the judgment dated so and so, where while holding the respondent number 4 to be not eligible to hold the post of vice principal, even on in-charge basis for a temporary period because of his ineligibility to be promoted to the post of vice principal, comma, as allowed the respondent number 4 to continue to hold the post of in charge vice principal of the homeopathic college till the post is filled up on regular basis. Post of. The learned single judge has directed the respondent authorities to fill up the post of vice principal of the homeopathic college on regular basis by following the extant rules, whichever by following the applicable rules within a period of 4 months from 8/5/2025. Post of para. Mr. Google and its additional advocate general appearing for the state respondents has submitted that. Is it mentioned that he has been suspended, principal? A peculiar situation has emerged, comma, in the meantime, comma, due to suspension of the principal in charge of the homeopathic college by notification dated 5/5/2025. Post of. And he has placed a copy of the seat notification before this court. Post of. Comma, it is noticed that the incumbent who was holding the post of principal of the homeopathic college on in charge basis has been placed under suspension by the notification dated 5/5/2025 with immediate effect pending royal of departmental proceedings. Post of. Well, as a result, it is the homeopathic college is the only institution in the state. Homeopathic college is the only institution in the state imparting homeopathic education and running a hospital along with a hospital. Post of. In view of the notification dated 5/5. No, in view of the situation emerging due to the notification dated 5/5/2025 and the observation of the learned single judge in the impugn part of the judgment dated so and so, whereby the respondent number 4 has been allowed to hold the post of vice principal of the homeopathic college on in charge basis. Comma, it would be the respondent number 4 who would be running the affairs of the homeopathic college till the process of regular appointment for filling up the post of vice principal is brought to a logical conclusion. Also, Mr. Natlan is senior counsel for the respondent of four to the judgment passed by a coordinate bench of this court in writ appeal number 12/2019 within brackets Sri so-and-so versus Sri so-and-so and another to submit that the similar situation arose in the said read appeal and the appellant therein was permitted to discharge his duties till the regular selection process for the post the appellant was holding was to be completed. Post of para on the judgment, the order in Sri so and so was with respect to selection and appointment. To a post which was to be filled up as per the policy of the government of Nagaland. First of the policy allowed the state and stroke appointing authority, the appointing authority to make appointment of a persons from the landowners who has donated land for establishment of any government institution in the locality. Full stop. The landowners policy of the state government of the government of Nagaland permits appointment in the lowest rank of the cadre. Full stop. Finding the appointment of the respondents therein, comma, the coordinate bench, while setting aside the private respondent's appointment, comma, had directed to complete the regular selection process for the seat post, as there was clear infraction of the principle contained in Article 14 of the Constitution. Full stop. Why not following the due process of selection? Full stop. While setting aside the appointment and directing the directing to initiate regular selection process, comma, the private respondent therein, the appellant therein, it was private respondent, appellant therein was allowed to continue was permitted to discharge his duties till the completion of the process of selection within a period of 3 months. Full stop. It is well settled that a decision spends on its own facts. Full stop. Having regard to the facts and circumstances obtained in Tuktinununga Miki Supra and the present case in hand, we are in respectful disagreement. To hold that and find that the decision in so and so is not applicable is of no assistance to the case of the respondent number 4 hearing. Poster. The in the case in hand, comma, the in view of the peculiar situation which have emerged, comma, no, in the case in hand, comma, it is for holding the charge of vice principal of the homeopathic college. Full stop. In view of the peculiar situation emerging from the suspension of the principal in charge of the homeopathic college in the meantime on 5/5/2025, if the respondent 4 is allowed to hold the charge of vice principal in charge till the completion of the selection process, as directed by the learned single judge within a period of 4 months from 9/5/2025, the respondent of 4 would, in essence, would be running the affairs of the homeopathic college, whereas he is not even eligible to hold the post of vice principal even on in-charge basis for a temporary period. Full stop. Para. In view of the above discussion and for the reasons recorded, we are of the considered view that that part of the impugned judgment whereby the respondent of 4 has been allowed to continue to hold the charge of vice principal of the homeopathic college on in-charge basis till the post is filled up on regular basis is to be interfered with, and it is accordingly interfered. Full stop. Para. In view of such interference, and the peculiar situation obtaining in the case in hand, the institution, that is the homeopathic college, there will be none either in the post of principal or in the post of vice principal, either in permanent basis, regular basis, or in charge basis, to run an institution of such importance. Full stop. In view of such piquant situation, the state respondents shall make necessary arrangements to for make all the endeavors to complete the regular selection process to fill up the post of Vice Principal of the Homeopathic College within the time as directed, within time period as directed by the single judge. Full stop. In the meantime, the state respondents shall also make necessary arrangements to run the affairs of the Homeopathic College. Either appointing by appointing a person, by appointing an eligible person, either to the post of principal or to the post of vice principal, on in charge basis. Charge basis. That will do. Or true. And or true. Are you having some averseness to the petition?
That is not academic side. Eligible person.
In the event of full stop, it is further observed that in the event there is no eligible person, the state respondents shall run the affairs on what basis? Administrative. But true. An administrative officer having the competence to run such an institution.
Eligible person from the gradation list.
In the event of,
No, prior to that.
in the event, no eligible person, I have indicated
Much,
to your benefit.
much like.
But Monday, I have some issues today. May not be possible to sign. Monday morning, before 10:30.
He should be happy now. He should be happy, very. Oh, it's fine.
The writ appeal stands disposed with the aforesaid observations and directions. No cost.
Number 9.
Please, your lordships. Statutory appeal, madam, is convicted under the NDPS Act, madam, 12 years imprisonment.
Mr.
As Nawaz, madam.
Heard Mr. S. Nawaz, learning counsel for the appellant. And Miss Endas, learning additional public prosecutor for the respondent state. This appeal, criminal appeal. Under section 4152 BNSS 2023 is preferred against a judgment dated 5/2/2025 passed by the Court of Land Special Judge Lakhimpur at North Lakhimpur in special within bracket NDPS case number 18 of 2021. Also by the judgment in order dated so and so, the accused appellant has been convicted for the offense under section 20 within bracket B within bracket small Roman 2 within bracket capital C of the Narcotic Drugs and Psychotropic Substances Act 1985 and he has been sentenced to undergo
It's 37.
rigorous imprisonment for 12 years and to pay a fine of rupees 1 lakh, in default of payment fine, to undergo simple imprisonment for 1 year. We have gone through the contents of the memorandum of appeal. The criminal appeal is admitted for hearing. The case records of NDPS case number so and so, copper. Issued notice, return evidence police, and Ms. So and so has appeared, accepted notice on behalf of so and so. Issued on the dispensary, extra copy of the move appeal. There is the case of corpus.
Development.
Item number 10.
And this is again, another statutory appeal, my lord, against the judgment under the 31/2023, the POSCO case.
Oh, my God.
Convicting under
Heard
section.
Mr. P. Kotopi. And counsel for the accused appellant and also
POSCO.
Miss Angus. One, yes, and like you, 415, I लिखा है सर, और no, good again लिखा है. 376, 36, 042, under section 6, 366. Now we have gone through the contents of the memorandum of appeal. And criminal appeal is admitted for hearing. Yes, records of so and so. Call for issue notice. As missed us, for respondent 1. Respondent 2, practice direction. And report as the service of notice from the officer in charge, CO of Police Station by the next date of listing.
Item 11.
It was me,
May I please your lordship?
London para. It wasn't. Yes.
The appellant had convicted by the
Right.
special POCSO Judge Sirang in special case number 46 of 2023 for a rigorous imprisonment of life
Right.
along with 25,000
Hard.
fine.
Mr.
A.K. Hannan, ma'am.
A.K.
Hannan.
Anand, Learning Counsel for the accused appellant and Miss Andas. Also,
Yes, my lord. Under section 6.
4152 BNSS. I had to leave now. The same, like his direction seems. Two.
Finding the item number 2.
But in this case, lordship, this petitioner is not assailing any particular order. That is that lordship, the representation which I've enhanced, the page number 46 is annexation number 7, in which he has prayed for consideration of his interest so far as the outstanding loan amount is concerned. But since it has not been taken into account, so that is the reason why lordship stating the.
What is the representation?
Lordship.
What is the representation?
Representation is at page number 46, lordship. The operative portion is at page number 47. The last page, lordship. There in the change circumstances and.
OTS.
Yes, lordship. This, the prayer for OTS is there, lordship. It has not been taken into account. and that is the-
They will do it.
Ah,
Why
Because-
there, no?
no, lordship. There is no communication on the part of the bank authorities, lordship. That is the reason why we approach this one.
Yes, ma'am. Case number 42, we have made a detailed reply.
a notice under 13.2 lordship. It's a notice under section 13.2 lordship. And now this thing, problem is the 13.4 surfacing notice has not been issued. So you're not in a position to approach the DRT with regard to that under section 17. Now, the fact is that when you have approached the concerned authorities under the OTS, so that aspect of the matter has not been taken into account. At least they should respond there.
Oh, TS, no, 226.
No, Lordship, inaction on the part of the responding authority, Lordship, we are highlighting that aspect of the matter, Lordship. Because they are supposed to give
It is
response because after 13.2 notice,
Preceding or subsequent?
subsequent, Lordship.
That,
Subsequent to that, Lordship. Prior to that also, we have made a
13 to 2024 May.
2024, Lordship.
And your application is
Recent
March 2025.
March 2024.
So
So at least they can respond, Lordship, because the fact is that since we are,
if they
we have
respond, it is
expressed
up to
our-
them.
we have expressed our difficulty.
We are not issuing in that. Yes, I have already held
Yes, sir. Is no urban also.
OTS
OTS cannot be claimed as a matter of law.
No,
226,
Yes.
no direction is called for.
I am not claiming any matter of right, Lordship. Fact is that
No,
they are
why
not
you
responding to
should-
that.
why
This is the main
should-
grievance
why
that we have
should-
expressed in our writ petition, Lordship. Because I can understand I am in the some difficult situation. Since the
Mhm.
petitioners are in a difficult situation, not in a position to pay the amount. And that is the reason why we have made a specific mention in our representation that we are this interest part, if it is possible to consider the interest part.
Urban Electronics, Biznor.
And is no urban.
Matters of one-time settlement and maintainability of a writ petition under Article 226 of the Constitution seeking a direction for consideration of the case under one-time settlement of.
No, I'm not praying on that, Lordship.
No, why should? Why should a direction, seeking a direction for consideration of a case?
No, I'm also not pressing for that, seeking a direction for consideration of OTS. What I'm,
This-
what I'm
What can be,
submitting-
cannot be done directly, cannot be done indirectly.
At least Lordship may give a direction to.
So no
dispose-
direction,
Lordship, to dispose of the representation within a short period of time, Lordship. That will suffice, Lordship.
no,
They may accept, they may reject my representation.
no.
Because,
This is an afterthought.
no, Lordship,
After
prior to
32,
that also,
after
Lordship-
32, no.
no, Lordship, prior to that also, there was a representation on our
No.
part for consideration of OTS, Lordship. Since that has not been taken into account, thereafter 13.2 notice, Lordship, now this representation.
Consider the prayer for. Your prayer entails dismissal of the writ petition. Heard. Mr. S.P. Choudhury. Learned counsel for the petitioner. And Mr. M. Sharma.
For 3 and 4 levels.
Learned counsel for the respondent number 3 and 4. First of. The industry petition, commander petitioner has projected that for running its business, they for the petitioners, huh? The petitioners have projected that they have maintained 1 or 2 cash credit account. 1.
Yes,
Yes, sir.
And they have maintained a cash credit account with the respondent number
4 levels.
with the respondent Axis Bank at its Silsar branch,
yes.
right? Since a considerable period of time. Full stop. As their arose requirement of financial assistance, They approached the respondent number 4 for a CC loan, cash credit loan, and the same was sanctioned in the CC account bearing number para 4 batas. First of it is stated that after availing the CC loan, the petitioner firm had to credit back 25 lakhs rupees to the state bank. First of due to demise of who is he?
Is the original proprietor lordship,
Mm.
subsequently it was converted to.
The original proprietor. On 1/8/2018, the petitioners had to challenge, had to face a number of challenges. First of on 5/10/2023. As there was default in making regular payment to the CC loan, the petitioners had approached the respondent bank authorities by submitting a letter on 5/10/2023, expressing their intention to settle the loan account under a one-time settlement scheme. Full stop. On the basis of the reply received by the respondent bank authorities, received from the respondent bank authorities, the outstanding loan amount, the outstanding amount, liability amounted to 1,54,84,481.64 at one point of time. So on, after consideration of the proposals, the respondent bank authorities made a communication on 3/11/2023 to the petitions, informing that the proposed settlement amount offered by the petitions, was not acceptable to settle the loan account. Thereafter, the respondent bank authorities has initiated proceedings under the SRPC with the issuance of a notice under section 13(2) of the State Act. Subsequent to State Act on
27/5,
27,
annexure 6, page 42,
page
42.
42. Mentioning the amount of rupees 1,54,84,481.64 as the outstanding liability. After classifying the loan account of the petitioner as a non-performing asset, since 29/01/2022. Oh, 06. Para. The petitioners have averted on 27/03/2025. The petitioners in response to the notice under section 13 within bracket 2 of the Circuit Act 2012 submitted a representation before the respondent number 4. Requesting settlement of the account under the one-time settlement OTS scheme of the bank, giving some monetary relaxation to the petitioners by exonerating the interest part from the principal loan account. Full stop. With the projection that the said representation has not been responded to, the petitioners have approached this court by the instant writ petition under Article 226 of the Constitution of India, seeking the following relief. Para na lage. Page 13, para. It is noticed that the Honorable Supreme Court of India, by its decision in State Bank of India, so and so business, so and so, reported in so and so, has considered the matters of one-time settlement scheme and maintaining the credit petition under Article 226 of the Constitution, seeking a direction for consideration of the case under one-time settlement of a financial institution bank. Para 19. 11. Close. No way. Let's see.
Yes, 12 and 34 orders.
Well,
Agree, Your Lordship. Yeah, in this case, my lord, paper book is otherwise ready, my lord.
Hmm.
Today it has come up for bail, IA, my lord, for suspension.
paperwork is ready,
Lordship,
same exercise. If
Lordship,
it is 45 minutes, appeal is up.
otherwise,
1 hour.
the only thing is, Lordship, we have not received the paper book. my lord.
Okay.
That is the whole problem.
You collect the paperwork.
Lordship.
What matter? POXO or
Lordship,
302?
302, Your Lordship.
Okay,
302.
service is not necessary.
Lordship, not.
Okay.
That has
Paperwork
been
is ready.
stricken.
We can put it in the hearing list
No, Lordship.
immediately after vacation.
Can it be, Lordship, my humble.
Paperwork is ready, then we'll do it.
Lordship, we have not received the same, my lord, and otherwise it is. kept
You
on- IA
make
is-
submission on IA, will do the exercise for hearing.
Lordship, Lordship. Then Lordship, for IA, my lord, that is kept open, in fact, on the last order. If you
You make submission on
Yes.
IA, will do the exercise for hearing, for disposal.
IA may be kept open. my lord,
Uh-huh.
Can it be on next week? my
IA
lord?
may be tagged there, but we'll put it on the hearing list. Paperwork is ready.
Lordship, it's,
Paperwork ready?
Yes,
Lordship. No point wasting time on IA. When paperwork is ready. Same exercise.
but I've been instructed, my lord.
Whatever is to be dictated in IA is to be dictated in the appeal. We do not want to do exercise twice. That what has been done by this court. Yes. We'll do the exercise once, not twice.
Was my lord, my humble prayer, can it be on
But
next?
because just vacation, otherwise we would have put you in the particular date, but after vacation. Okay, after vacation, we will not pass any order. As soon as we see the paper book, we start. hearing the appeal. Will not pass any order on the IA today. Okay, you correct the paperwork. Heard Mr.
R.A. Chaudhary, Lordship, on behalf of my
R.
senior,
A. Chaudhary,
on behalf of my senior,
Learned Counsel appearing for the appellant in item
2012.
12. Yes, Mr. Ali, are you pressing IA? You have collected. Okay, Mr. R. Ali, Learned Counsel for the appellant in 13. And Ms. S. H. Bora, Learned Addition Public Prosecutor for the respondent state. Also, Mr. Chaudhary, Learned Counsel for the appellant has, Chaudhary, right? Has submitted that he is yet to collect the paperwork postal. And he will collect the same within, by the, within, on or before last date to review. 27/6/2025. Postal. List the cases on.
Lordship, by then, they will file the objection, my lord, that is. If,
List the cases on so and so date.
file. Detail.
Oh, should vote it, please. 20, huh? 20, not 21st. 28 one of video. 27. No, we are not passing any order. So you collect it. If we, in the course of your submission, you find that yes, appeal can be disposed of, we'll dispose of the appeals. We are taking up hearing every day.
It is about 14. What I responded.
Responded. Boxo.
It is about 15.
May it please, your lordship. Lord, the instant habeas corpus petition is for the release and custody of the minor child. Is it about 5 years? My lord, I am the biological.
From the classes of whom?
My lord, he is one of the maternal auntie. My lord, actually respondent number 4, he has taken up the child. And now he is saying that it is not with him, it is with his maternal auntie. Now, I'm the biological father. My lord, what happened in the meantime? My lord, my wife committed suicide. And my lord, there was an FIR filed against me by respondent number 4. And I was in the custody, and that period of time, he taken away the child. And now he's saying it has been handed over to his maternal auntie.
Maternal?
Now, maternal auntie. Now, my lord, we filed an FIR before the.
Maternal aunt is alone.
No. She has how many children? Some children, she has her own family. Now, the question would be, my lord, since I am the biological father, the care I will take the way she cannot take because she has her own children. So the secondary love I may get. But then the primary, my lord, the care to be taken. So for the child is concerned, it is by me only. So my lord, we filed an FIR before the police. Police did not do anything. They did not file any affidavit also saying that what they did. Now, in the meantime, respondent number 4, he is saying, he has said so many things, my lord. Now, presently, my lord, what they have done, after getting the notice, my lord, they have filed an custody petition before the family court. Now, my anxiety is this, my lord. If I am to contest there, I'll go, obviously, I have been imputed as a party, I will appear there. But then question of handing over the child to me is very imminent in the nature. My lord, your lordship will see to that extent only, so far the custody petition is concerned. Now, your lordship, since I am.
As I am not very much accustomed with this kind of matter, just my first query is whether a biological father always has the indivisible right to have the custody of the children.
My lord, your lordship is very right in putting that
No, I
question.
am just putting the question.
Yes, yes,
Has always
yes. My lord,
the indivisible right.
right. And that's the question, my lord, I am required to answer. Now, my lord, if your lordship, if I take your lordship a few decisions of the appeals court, that question posed to me also. Now, I found in a situation like this, since I'm the natural father, the biological father, the imminent nature of taking care is rest upon me. The auntie, what sort of interest she has, what she's doing, what,
Auntie is alone or with his
no, with
parents,
the family.
grandparents?
No, she has her own children. She is there about possibly
The
50.
child has a grandparents also from the maternal side?
No,
No grandparents.
now that.
How old is the child?
Child, no, please. Huh? No.
Not born on 6/5/20. 6/5/20.
5 years.
Almost 5 years.
Boy or girl?
Girl. No, my lord, if I take your lordship to certain decision of the appeals court to, my lord, persuade your lordships, that what is the position of under 226, how far your lordship can.
For a writ of habeas corpus, we have to first find out whether there is any illegality.
Beg your pardon. Illegality, right? Your lordship is very right. Whether the.
Thereafter, we can go into the second question.
Yes,
In a writ of habeas corpus.
right, very right.
So whereabout is known. Whereabout is known,
Yes.
right?
Right.
Unlike all these other petitions going around,
Yes.
picked up in the middle of night because of declared foreigner
Right.
status. Here is the case, the whereabout is known.
Yes.
Question is also the who is having the custody present, that is also known.
Yes.
And the fact of the matter is that the child is a girl child. Who are with you?
I'm having another 2 children.
And a wife.
Oh,
The first one.
then it would require some determination.
You know, if your lordship allow me to take up those decisions, you know,
We may have an interaction with the child also.
yes, I like it that way, because after all, my lord, your lordship will take all care to see what is her intention, whether she like to go to with her father or not. Because your lordship's in.
Because it is a paramount consideration of the child, perhaps.
Exactly, very right.
A custody petition has already been filed.
Yes. But then your lordship kindly see, that application has been filed only to protect themselves. Because the allegation is that because they are not entitled to take the custody of the child. Now, supposing in the absence of me, my lord, they have taken very well.
Which provision governs
Section 6, my lord,
of?
my lord, your lordship can see at page 13 in our petition, my lord. WBC Criminal 5 of
Hindu
2025.
minority guardianship act concern. Hindu minority guardianship act.
Section 6 I have quoted, my lord. Your lordship may see at page 13. Section 6A, your lordship can see. In the case of a boy or an unmarried girl, the father and after him, the mother, provided that the custody of a minor who has not completed the age of 5 years shall ordinarily be with the mother, B, in case of an illegitimate boy or an, we are not concerned with that. In the case of a married girl, the husband. Now, these, my lord, we are required to see this.
Insurance. Six of the custody. This is the only act,
My lord,
only act,
yes, yes.
only act. Section 6 is the only provision.
There are other section 13 is also there. So my lord, the welfare of the minors of the paramount passenger.
By court.
What's in section 13?
Section 13
Yes.
of the same act. This is regarding natural guardian,
Yes,
section 6. Natural guardian.
yes,
The question is about custody.
custody,
This is a declaration about natural guardian.
my,
6.
yes, 6. Regarding natural guardian,
Whether guardianship and custody is same concept.
concept will be more or less same, but
May
your
not
lordship will,
be, may not be perhaps.
your lordship will see the paramount interest of the minor will have to be seen here.
So natural guardian may not always go with the custody. The two concepts may be different.
My lord, in this case, my lord, my submission would be,
I think
my lord, natural guardian, he is the person who will take all care in regard to the minor.
absolutely.
And so far the extraordinary jurisdiction of your lordship will see who is the natural guardian. The apex court is saying, if one is the
No,
natural,
Apex Court does not have to say. It is already said.
yes, it is already there.
It is already said.
My lord.
You are the natural guardian. And in absence of the mother,
Yes,
always
exactly. That
you are the
position,
natural guardian.
that position is clear.
That is, that has not been,
No.
is not required to be clarified by the Honorable Apex Court.
No, what I'm saying, whether under 226, your lordship will like to pass that order or not. I just want to persuade your lordship to that extent. Your lordship may say
Because it is a matter of custody.
custody.
And the attending facts are required to be taken into consideration.
That's why, my lord, if I take your lordship, three decision of the apex court, possibly for giving the release of and the custody of the minor, possibly your lordship has the jurisdiction to pass such order.
Custody, we don't know, let us see.
Yes, my lord, I'll take your lordship's decision of 2019 7 SCC, page 42.
Is there any birth certificate of the child?
Yes, yes.
Where is that?
I have annexed that one. Please. Affidavit. Page 34, maybe.
34. Just,
The name is Arpita Datta. Date of birth 5/6/5/2020. And the father's name is Pulak Datta. In the right hand side, you'll also will find.
Yes.
Now, this is the birth certificate. Maybe. And
Yes, which, the decision?
a decision, my lord, 2019 7 SCC, page 42, paragraph 14, your lordship NVC. I'll take your lordship to 14 and 19. Writ of habeas corpus is a prerogative process for securing the liberty of the subject by affording an effective means of immediate release from an illegal or improper detention. The writ also extends its influence to restore the custody of a minor to his guardian when wrongfully deprived of it. The detention of a minor by a person who is not entitled to his legal custody is treated as equivalent to illegal detention for the purpose of granting writ directing custody of the minor child. For restoration of the custody of a minor from a person who, according to the personal law, is not his legal or natural guardian, in appropriate cases, the writ court has jurisdiction. Then, your lordship, kindly see paragraph 19. Habeas corpus proceedings is not to justify or examine the legality of the custody. Habeas corpus proceedings is a medium through which the custody of the child is addressed to the discretion of the court. Habeas corpus is a prerogative writ which is an extraordinary remedy, and the writ is issued wherein the circumstances of the particular case, ordinary remedy provided by the law is either not available or is ineffective. Otherwise, the writ will not be issued. In child custody matters, the power of the High Court in granting the writ is qualified only in cases where the detention of a minor by a person who is not entitled to his legal custody. In view of the pronouncement on the issue in question of the Supreme Court and the High Courts, in our view, in child custody matters, the writ of habeas corpus is maintainable where it is proved that the detention of a minor child by a parent or others was illegal and without any authority of law. In paragraph 20, in child custody matters, the ordinary remedy lies only under the Hindu Minority and Guardianship Act or the Guardians and Wards Act, as the case may be. In cases arising out of the proceeding under the Guardians and Wards Act, the jurisdiction of the court is determined by whether the minor ordinarily resides within the area on which the court exercises jurisdiction. There are significant differences between the inquiry under the Guardians and Wards Act and the exercise of powers by a writ court, which is summary in nature. What is important is the welfare of the child. The Read Court rights are determined only on the basis of affidavits, where the court is of the view that a detailed inquiry is required. The court may decline to exercise the extraordinary jurisdiction and direct the parties to approach the civil court. It is only in exceptional cases the rights of the parties to the custody of the minor will be determined in exercise of extraordinary jurisdiction on a petition for habeas corpus. So therefore, my lord, your lordship will find this is an exceptional case where the custody has been taken by a person who is not entitled to take it. Para 21 also helps us.
And what are the decisions?
Yes, my lord, the next, my lord, I will take your lordships to 2001 5 SCC, page 247. The relevant paragraph, my lord, I will rely on paragraph 9, 11, and 13. Paragraph 9 at page, my lord, 251. A constitution bench of this court in case of so and so. Paragraph 9. At page 251. Lordship got it. A constitution bench of this court in the case of so and so, dealing with the nature of scope of writ of habeas corpus, observe. It will be seen from this brief history of habeas corpus that it is essentially a procedural writ. It deals with the machinery of justice, not the substantive law. The object of the writ is to secure release of a person who is illegally restrained of his liberty. The writ is no doubt a command addressed to a person who is alleged to have another person unlawfully in his custody, requiring him to bring the body of such person before the court. But the production of the body of the person detailed is directed in order that the circumstances of his detention may be inquired into, or to put it differently, in order that appropriate judgment be rendered on judicial inquiry into the alleged unlawful restraint. The form of the writ employed is, we command you that you have the King's Bench Division of our High Court of Justice immediately after the receipt of this writ, the body of AB being taken and detained under your custody, together with the day and cause of his being taken and detained, to undergo and receive all and singular such matters and things as our court shall then and their consider of concerning him in this behalf. The italicized words show that the writ is primarily designed to give a person restraint of his liberty, a speedy and effective remedy for having the legality of his detention inquired into and determine, and if the detention is found to be unlawful, having himself discharged and freed from such restraint. The most characteristic element of the writ is its peremptoriness and, as pointed out by Lord so-and-so, the essential and leading theory in the whole procedure is the immediate determination of the right to the applicant's freedom and his release, if the detention is found to be unlawful. That is the primary purpose of the writ, that it is substance and act. Then your lordship, paragraph 11. From the principles laid down in the aforementioned cases, it is clear that in an application seeking a writ of habeas corpus for custody of minor children, the principal consideration for the courts is to ascertain whether the custody of the children can be said to be unlawful or illegal, and whether the welfare of the children requires that the present custody should be changed and the children should be left in the care and custody of somebody else. Then ultimately, in paragraph 13. From the conspectus of the discussions made and the reasons stated in the aforementioned paragraphs, it is clear that the order of the High Court is unsustainable and has to be vacated. Accordingly, the appeal is allowed and the judgment order of the High Court dated so-and-so in WPC number so-and-so set aside. In view of the fair concession made by Mr. So-and-so or its senior counsel, appearing for the appellant, it is ordered that the custody of the two children will remain with their mother, who is respondent number 1 hearing, till the family court disposes of the petition filed with the appellant for their custody. It is further ordered that the appellant shall pay the amount spent for treatment of respondent 1 in Princess Geo Saving Children's and General Hospital, Hyderabad. If any amount is yet to be paid, that's a different thing. Now,
And what is the fate of the criminal case?
my lord, in our case,
Criminal case.
now charge sheet has already been given.
Charge sheet is there. You are the only one?
Yes,
Charge sheeted?
my lord.
The wife is also there. First wife.
That is why I am asking.
First of all,
My lord.
Who are the persons charge sheeted?
That's page number 76 of mine.
I'm told, my lord, first wife and the petition.
Okay. So you and your first or second wife, whatever,
First,
are supposed to take
custody.
supposed to take care of the welfare of the child.
My lord.
These facts are to be looked into then. Which one?
My lord,
Charge sheet.
my offense. Is number 76, 75, the charge sheet,
Offenses
306, my lord.
306. 306. Abatement to suicide. Ulog Dotto, Dolly Dotto.
Next page is.
I am looking into the Assamese one, 79. Ulog Dotto, Dolly Dotto, 306, read with 34. Okay, we'll put it on Wednesday. We'll go through the records. We'll read it. Because it is not that easy.
Yes. That's
Facts are to be looked into.
my lord. Definitely.
It is not like preventive detention law.
No,
So the ordinary principle of habeas corpus is not applicable.
no, not applicable.
It has to be with some more
Right.
touch
Yes.
and sensitivity.
Yes, yes.
It is not state
Right.
against whom we can go whole hog.
It is not that kind of.
It is not that with some touch and sensibility.
Right.
taking note of all the attending facts and circumstances we have to look into. We'll go through this
Sure.
records.
Child lives next door, the person who has the custody, the maternal aunt, so
Huh.
next door. to the-
Next door.
Next door. So it's not like they do not know the whereabouts. She is admitted to Kidsi, so every day the father, the petitioner here, he can see that the daughter has been taken to Kidsi and next door she lives with the
Okay.
maternal.
Okay.
So these are the basic facts.
There's the not the question for determination.
No,
Determination
but
whether-
all facts are required
Yes,
to be
yes,
looked
yes.
into, definitely.
Legality, my lord, the child was taken by the grandmother and the maternal aunt when the petitioner was arrested. There was no one to take care of the child. So the illegality is not there.
Very fine. But then the next question would be, if you are so fair enough, it was your duty when he came, you should have handed over. Because you are not entitled to get the,
But you and your, what, first or second wife are there,
yes,
and at least prima facie, though presumed to be innocent, prima facie,
man,
and principle of criminal jurisprudence will always apply,
yes, yes.
right? But that has to be looked into. All this, I will go into it.
Lord, what I
Okay,
feel-
give it, because I am fairly making
Yes,
admission that I am not very accustomed to this.
what I feel your lordship is.
Had it
guardian.
been IPC, CRPC, no issue for me. But
My lord,
this is a sensitive matter,
so very sensitive.
so we have to handle with care.
And that's the reason I feel your lordship is also same time as the guardian of the petitioner.
We have to find out. So this is why, okay, we'll record the cases by Mr. Dotto and Mr. Avan. What will the case do that? Even to the asli duta. Okay.
Can I hand over another decision? my lord?
Sure. So. This is your case. In one case
My
or
lord.
two?
But one is more than enough.
One is more than enough.
It's 2024-9 SSC 320.
Ah,
So paragraph 9.
okay, you have marked it.
Fine.
Okay, good. Okay, Tejaswini God is also considered.
In this case, it's been
Aha.
considered.
Mr. Doctor cited case.
My lord.
Okay.
In this case, it is considered.
Okay.
Why it was not correct, my lord. That is also been discussed.
2009, 1 SCC, page 42. I'm marking paragraph 45 to 40.
Yes, sir.
Your lordships feel that to the presence of the guard
We'll
is
first
required.
see it and
Yes,
do the needful.
well,
Will not try, I'll not jump into,
yes,
I'll not jump the gun.
right. After satisfaction of your lordships.
We may take the assistance of Legal Services Authority or something like that. We'll do that because I am not very,
I'm also
Think-
doing the first of its kind.
I am also doing it first of, and during profession, by choice, I did not do any case. Because really, either mother or father, yes. Your instruction, you are for state. Huh? State. What kind of instruction? Any instruction was asked for? Huh? Wherever is known now. Whereabout is always known. Okay, heard Mr. S. Dottal and Senior Counsel yesterday by Mr. B. Sharma and Counsel for the petitioner. Mr. A. W. Aman and Counsel for the respondent. Number 4. Mr. Also heard Mr. N. Kolita and State Counsel. Mr. Kolita has This. An office letter number so and so dated 18/3/2025 of the Superintendent of Police, Lorong Mongaldoi, from my address to him. First up, the said office letter dated so and so is kept with the case record by marking it as document X. List the case on Wednesday.
Obliged. Item 16 and 17.
Why you have preferred this?
Again, this equated.
Equital.
Yes.
One, the LP petition, leave petition.
BNSS comes out. BNSS. BNSS.
Leave petition, criminal leave.
Lead petition, why lead petition? What is equivalent to Ms. Dora? Equivalent to 372, provide you? In BNSS? Is it a case against acquittal? Huh? Acquittal. Now let us see 413. Now, where is the judgment?
Judgment, your lordship says
Page?
page number 10.
Page number
From-
10.
From 9, my lord.
Page number 10.
9,
So it was lodged an FIR, Mohiruddin Sheikh,
yes,
right?
yes.
And FIR was registered.
Register, my lord.
Registered as Lokipur Police Station, case number 218 of 2010, right?
Yes,
And thereafter, search sheet was submitted.
submitted 3.
And sessions case, so sessions trial.
Yes.
Now, take us to 419, where it is maintained.
Yeah.
Where? 419. You filed this appeal under 419, leave to appeal.
Leave it.
Where?
Leave
Give the CRPC to Mr.
For the BNL.
BNSS, okay, BNSS. You filed this appeal under BNSS, 419.
Yes.
Which provision of 419? Which provision of 419?
Appeal against the acquittal.
Where? Which provision? 419. Miss Bora, hand it over the BNSS. Or you take this one. 41. Because I am also learning BNSS.
But appeal in case of acquittal, save the otherwise provided in subsection 2 of the certificate. District magistrate.
Have you read it?
District magistrate may in any case direct the public prosecutor to present an appeal to the court of session from the other of the acquittal.
Mr. Hussain, have you read the provision before filing the leave petition? My first question is that. Read four. Read four, first line.
Even otherwise provided in subsection 2 and subject to the provision of subsection 3 and 5. And my lord, this B, the High Court.
Subsection, read, huh?
B, my lord.
I have,
The High Court from the original appeal order of acquittal passed by the any court other than the High Court, not being an order under clause A.
these are district magistrate. Right. Read the first part.
First part. The district magistrate may in any case direct the public prosecutor to present an appeal to the court of session from an order of acquittal passed by a magistrate in respect of the cognizance and not cognizance offense. The state government in any case direct the public prosecutor to present an appeal to the High Court from the original appeal order of acquittal.
These are
passed
district magistrate, state government, public prosecutor. Subsection 1.
my lord.
Subsection 2, CBI.
Subsection B, my lord.
Read.
B.
If
The state government in any case direct to the public prosecutor or present an appeal to the High Court from an original or appellate order to acquittal
state government,
passed by the court
public prosecutor,
or my lord, or appellate order of acquittal.
he is filing a leave petition. Filing the leave, before filing the leave petition, he has not gone through the provision. That is a problem. Subsection 4 of section, that is why I read him, Lakhipur police station, FIR, not a complaint case. That you have to seek leave. This is unnecessary filing. You correct the cause title in a connected writ petition. Sorry, writ appeal by going to the registry. Okay. I go ahead. Heard Mr. J. Hussain, learned counsel for the appellant, and Miss I 656, 2025. And Miss S. H.
653 is the condemnation.
I am not a teacher in a college. S.H. Bora, learned additional public prosecutor for the opposite party, that's state. Respondent, that's state, comma state. Post of this by instant application under section 5 of the Limitation Act 1963 is preferred seeking condonation of delay of 74 days, which have occurred in preferring the connected criminal appeal filed purportedly under section 4. Your time is the guideline. 419, Bharatiya Nagarik Surakha Sanhita 2023, which ought to have been under the proviso to section 413 of the Bharatiya Nagarik BNSS, against a judgment and order dated 21/12/2024, passed by the Court of Learned Session Judge Gwalpara in Sessions Case number 214 of 2024. Post up. In the trial of Sessions Case, 214/2014, the opposite party number 2 and 3 face the trial for charges under section 341, 326/34, Indian Penal Code, and Sessions Court by the judgment and order so and so, have acquitted the opposite party number 2 and 3 from the said charges. Close up. Issue notice returnable in force. The applicant shall take steps for service of notice upon the notice as Ms. Bora, opposite party number 1. Appear accepted. Applicant shall take steps for service of notice upon the opposite party number 2 and 3 by registered post with AD within 3 working days from today. So stop. Email repetition likable. The heard Mr. J. Hussain, learned counsel for the petition applicant, and Ms. S.H. Bora, learned additional public prosecutor for the opposite party number 1, State of Assam. Post of the instant application seeking grant of special leave has been filed under section 419 BNSS applicable 23 to file a criminal appeal. No, sorry, as a special leave to file a criminal appeal under section 419 of the Bharatiya Nagarik so and so against the judgment and order dated 21/12/2024 passed by the so and so face the trial opposite party number so and so acquittal hobo in view of the on perusal of the judgment and order dated so and so, we find that the applicant hearing as the informant lodged a first information report before the officer in charge, Lakhimpur Police Station on 11/1/2010. And on the basis of the said FIR, Lakhimpur Police Station case number 218/2010 was registered for offences under section 341/326/34, IPC. In the FIR, the informant applicant had alleged assault on his son by the accused persons. on submission of the charge sheet, against the opposite party number 2 and 3 hearing under section 341, 302, 34, the session's trial had commenced, and thereafter the judgment and order of acquittal was passed. Post of special leave to appeal for informant to file an appeal under section 419 BNSS, which is perimeter to section 378 CRPC, is required in the event, the case has been instituted on the basis of a complaint, which is not a case. Full stop. The proviso to section 413 BNSS, which is perimeter to section 372 CRPC, does not require any leave, not to speak of any special leave, to prefer an appeal against a judgment. Uh, 413. If against any order passed by the trial court acquitting the accused or convicting for a lesser offense or imposing inadequate compensation. Question. In view of such position of law, by instant application styled as a criminal, leave application seeking leave to appeal does not require any adjudication, and the same stands closed. You don't do the exercise at home, you waste court's time. Well, that is, in the IA, while issuing notice, I said purportedly file, which ought to have been. It is up to him now to go and make the correction. If the wise sense does not prevail upon him, what to do? I have already issued notice to expedite the matter. That much I can do. I cannot go to the registry and correct it for him.
Maybe allowed to correct.
It is up to you. I have already said. I have condoned that. I have condoned that, which ought to have been. I have said.
What about 14? This is good.
Yes, it is so. No, it is up to you. We have no option.
And all the time, is it coming from that side, man? Some consider we have got difficulties, but then I am nothing to say.
I am told you are not feeling well.
I'm to go, my God.
No, I haven't put.
Somewhat some feeling of the. Anyway, but.
No, it is up to you to decide. We don't decide about this.
No, I am ready, my God.
Okay,
That will be after vacation. They are already.
If possible, my lord, if whether this bench is there, my lord. Your worship is once gone, my lord.
custody, how long is the custody?
10 months, man.
10 months.
Yeah.
Offense?
Offense, my lord, your worship.
POXO?
Also is there. Also is there.
6 of.
But case is, my lord, if your worship can go to that year,
Hmm.
17.5 years as per FIR. And
No, did you take that plea?
yes, it is in the
Also received the copies of the same post of list the case on 16/7/2025 for consideration of the application.
published.
In the meantime, I'll pass the order in the appeal also. Heard so and so, taking video. As the case records of so and so case number have been received, office to prepare the paper book, list the case on 16/7/2025 for a report as regards readiness of the paper book. Leave me.
Item number 23.
Ms. Bhuya, perhaps.
It has come for hearing for a mind for two couple again.
Hearing or no, we thought that we will hear the matter. Paper book is ready. It is only for that purpose. Yesterday, I think,
Yes.
Yes,
uh,
yesterday.
Yesterday.
It is now the 3:30 minutes.
no, otherwise we thought that we will hear the appeal. Since paper book is ready, half an hour, IA, 1 hour will be appeal.
So whether today or
No, it is up to you. We are sitting here. Okay. But next week, not possible perhaps. No.
if possible.
No, on Tuesday, all these NDPS matters are fixed. 4 appeals, right? Monday, I have fixed a matter for immediately after vacation, we can do it. We can take it. For hearing. 15th, we can take it on 17th. No, not by that time. Many things may change. 22nd of July. Region of 22nd of July. 23. HR Chaudhary. Now, Seneca says, stated by Mr. Ayu Chaudhary. For the appellant, A. Begum. You were there. And then additional public prosecutor for response number 1 state and NK Das when responsible for the response of who were present. Post to list the case for hearing on 22nd. I would give an observation if the appeal is not heard, something like that.
Yes. The worship for the meeting. That is that kind of prior to the amendment, after amendment.
All right, that on that point you have a case.
Yes.
At least for reduction, absolutely.
Yes.
But if you can get acquittal,
Yes, otherwise I have kept, but even then.
even
Yes,
then.
yes.
You have to observe Kuras.
Your worship 2 times your worship has answered. They might have.
9/6/2025 লিখে দিব list the case so and so I will let you go. It is observed that in the event the appeal could not be heard on the next date and endeavor will be made to consider the interlocutory application I criminal number so and so. Both the conditions are satisfied.
But
May it please your lordship. My lord will peruse the order dated 13/6. Now, my lord, the difficulty that has arisen is on 13/6, we were directed to take steps by Dasti upon all the respondents. on 13/6 itself, we took steps. Now, the dusty notice that is prepared by the concerned section and then handed over to us. Now, that has been given back to us day before yesterday, that is on 18/6. Now, the petitioner hails from Sibsagar. And in fact, he has come down to Guwahati just yesterday to take this notice so as to effect.
And Mr. D. Chakravarti, Learning Council for the petitioner, Mr. Chakravarti has submitted that. As per by order dated 13/6/2025, the petitioner was permitted to take steps for service of notice on all the respondents by way of dusty to the registry. He has submitted that though steps have been taken immediately for service for issuance of notices, he has the registry has supplied the notice to the petitioner only on 18/6/2025. As the petitioner he is from Jorhat and the Sibsagar, and the respondents are from Sibsagar and Jorhat, the notices by way of dusty could not be served by today. So he has thus sought for some more time to serve the notices by way of dusty. List the case and to submit a compliance affidavit to that effect. List the case on Thursday. The earlier the observation made earlier to the effect that no coercive action shall be taken against the petitioner till the stands reiterated till the next bit of listing.
My lord, today's order may also be required to be taken because now the.
Okay, will be signed, uploaded. Hearing basket. Possible no, possible no. Poxo. Not possible then today. Who is this man? 10 years, 9 months. Ranglal Bhumis. Legs. Yes, Miss Begum, Ranglal Bhumis, 10 years, 9 months. Mr. Das, your client is only 2 years, 5 months.
Well, now the fair man.
Huh?
Did not culminate into marriage.
Anyway, item number 19, he is in jail for 10 years. 9 months. Yes, Mr. Chakravarti.
But at least one.
Okay.
But
You don't want to comment.
He's in jail for 11.
That is
11
right.
years. Next Tuesday or Thursday.
No, Tuesday, Thursday, like, all our motion days and this bench has been given also read petitions, read appeals. We don't know.
Immediately
After vacation then. Will not fix any dates.
Not
But
sure.
concerning that, I have already given information to the registry. Whoever is in incarceration for longer period, those appeals are to be listed expeditiously, but they will do the job. Okay. B. Chakravarti, Learned Counsel for the appellant, and Miss A. Begum, Learned Additional Public Prosecutor for the respondent state have conjointly submitted that this appeal be listed immediately after the ensuing summer vacation. First of as sought for, list the case on a date immediately after the ensuing summer vacation. Will not pass any order in 18. Let it be.
Then will it be considered on the next date, my lord, because.
Let it be rollover. Whenever it is there, we'll take up.
No, yes, hearing, but IA has not been disposed as such, my lord. So
Maybe for region
no,
obvious,
that kind of pending is.
it has reached the stage of hearing, meaning thereby court may not be, was not inclined
Since
perhaps.
paper book was ready, that is why.
We'll see that. You see. 20, item 20. Nine. Password, 20.